Welcome. I hope everyone can hear me out there. Hey, welcome to our webinar series. I think we had a break last month and it's good to be back into them again. Welcome to our webinar on changes to casual workers. We've been very fortunate to have Ben Wright from South Geldard Lawyers here today to do that presentation on those changes to casual workers. Also, Wendy is going to do a little update on the budget as well at the end. This won't be a long presentation, guys, so please do shoot through some questions. We hope to get to them all, but if you can get your questions on the chat line, we'll attend to those as well. Right, well, first I'll do, Wendy's going to do hers first up. So we're going to do the budget first up, and then I'll introduce you to Ben once she's completed. So, yeah, hand it over to you, Wendy.
Good afternoon, everybody. I just thought I'd run everyone through just a couple of the more important changes that we saw come through in the 2020 budget, which was delivered on the 5th of October. And there are a few areas that we are fielding some questions on here in the office, so it might be helpful if we run through them this afternoon. One of the first areas that we're getting the most questions about is a temporary full expensing of eligible capital assets. So the government's announced that it will amend the tax law so that businesses with aggregated turnover of less than $5 billion will be able to deduct the full cost of eligible capital assets in the year they are first used. So this means all capital assets will be fully expensed in the first year that they are bought. This applies to new assets, and it also applies to second-hand assets for businesses with an aggregated turnover of less than 50 million. And it also includes the cost of improvements to existing eligible assets. So this applies for all assets acquired from 7:30 on the 6th of October and first installed or used by the 30th of June 2020. And those of you who have existing general pool balances, these will all be fully expensed in the next tax year as well. So in the 2021 tax year, all your general pool balances are able to be written off as well.
So Wendy, doesn't matter what your balance value is?
Doesn't matter if your pool balance is 500,000 or 151,000, they'll all be written off. And it doesn't matter whether you buy an asset for 151,000 or $1 million, it will all be fully expensed.
Yep. So in other words, basically any capital acquisitions, as in plant and equipment, really, it's a straight tax deduction now.
Straight tax deduction.
Yep. So it's probably going to mean a lot of profits, or taxable profits, I suppose, are going to be a lot less than previous years.
Yep, they're going to be a lot less than previous years. And on the flip side, if and when this finishes, if you then sell that asset, you actually won't have anything to write it off against. So any money you get from the sale of that asset will be fully taxable going forward.
Yep. So there's short-term benefits there.
Short-term benefits.
But the long-term consequences?
There are some long-term consequences that you just got to be aware of. And it's probably going forward, planning some of these things will become really important.
Yeah. And you did mention second-hand assets.
Yeah, so this is always a bit controversial whether second-hand assets are in or out. This time they're all in, providing your turnover is less than $50 million. So I'm imagining for most people listening, any second-hand asset you buy will be fully depreciated. The only catch to this one is the luxury car tax limit still exists. So the luxury car tax limit for the 2021 year is just over $59,000. So if you buy a car for $70,000, you can only claim the first $59,000 as a tax deduction, and the rest there's no depreciation on.
Right. Yep.
Cool. The next item of the budget that will be interesting for some people is that there's two elements to the JobMaker plan. The first one is boosting the apprentice wage subsidy. So this apprentice wage subsidy we've seen during COVID times, and the government's taken it to extend it through to the 30th of September 2021. Previously, there was employment limits, so you had to have full-time employees less than 20. There's now no limit on the amount of employees to be able to claim this one. So if you have an apprentice or a trainee, you can get 50% of their wages reimbursed per quarter, up to $7,000, and that will continue till 30th of September next year.
Rightio. So you're saying that it's no limit on the number of apprentices or trainees?
No limit on the number of apprentices or trainees, and also no limit on the number of other employees.
Yep.
Before you had to have less than 20, now it's open-ended.
Open-ended. And it's $7,000 per quarter?
Per quarter.
Per trainee?
Per trainee.
Rightio. Yep. So I could put on 6 trainees and potentially I would get the 6 by the 7 per quarter.
That's it.
Rightio.
So that one I think a lot of people will be able to use.
Yeah.
The next one that got lots of airtime on TV was a JobMaker hiring credit. So when this first was announced, we all thought, you beauty, this looks really, really good. Now that the details come out, I'm concerned that it will be very difficult for people to access this. So the government announced that it will provide $4 billion to accelerate employment growth by supporting organisations to take on additional employees through a hiring credit. So this program is actually administered by the ATO, very similar to what JobKeeper's has been done. And the JobMaker hiring credit will be available to each eligible employee over 12 months from the 7th of October for each additional new job they create. So the very important wording in this is it has to be additional new employee. So what's happening is the ATO will have everybody's baseline employment data from single touch payroll, and you'll actually have to create a new position. So you'll have to go from 7 employees to 8 to be able to be eligible for this.
So if I go from 7 and fire 2 people, sack 2 people and go down to 5, and then a couple of months later put 2 back on, it doesn't sound like you're going to get that?
No, it doesn't sound like it.
No.
So
that was my understanding of it too.
We're still, like, the detail is still being fleshed out for this, but at the moment it's each additional new job. They'll create a baseline date and look at your employees, and it will be new ones from that date.
Yeah, yeah.
And the eligible employee, there's actually quite a few rules and regulations around this. It's not just age-based. So an eligible employee is somebody who's 16 to 29 years old, will attract a payment of $200 per week, and the 30 to 35-year-old age bracket will get a payment of $100 per week. They have to have worked at least 20 hours for you on average for the full weeks they were employed over the reporting period. They have to commence employment between the 7th of October and the 6th of October 21. And this is probably the hardest part for people, is they have to have received job seeker payment, youth allowance or parenting payment for at least 1 month within the past 3 months before they were hired.
Oh, rightio.
So that's probably going to make employing people who fit into this quite difficult as well.
There's going to be a lot of ineligible people, isn't there?
Yeah.
Yeah.
So what we originally thought was going to be great, it's probably got a lot of limitations, and you're probably going to have to make sure you tick a lot of boxes if you want to fall into this one.
So the first criteria really you're going to have to look at is whether they're getting job seeker or youth allowance.
Yeah.
If they happen to fall into that, then we probably look at whether they're 16 to 29 and you're going to get, 10 grand a year?
Yeah.
And then, or if they're 30 to 35, you're going to get 5,000 for them.
Yeah.
Only as long as you've increased your numbers of employees as well.
That's right.
So, it's not as easy as first thought.
Yeah. So there is a lot of devil in the detail for that one.
Yeah.
Cool. Those were the main things that came down in the budget, and I'll now very happily hand it over to Ben Wright, who's the Director of South Geldard Lawyers, who's kindly given up his time this afternoon to come and talk to us about casual employees. There you are, Ben. Just click the mouse to make it go.
Thank you very much, Wendy. Mark, thanks for having me, and thank you for tuning in, everybody, giving up some of your valuable time. Apologies in advance if I get things out of order with the slides. Technology has never been my strong point.
Just click that. Is that one? Yep. And just click it again. There.
So today I'm talking about the issue of casual employment, okay, and issues that employers may now face given some recent cases that have come before the courts and the decisions of those in those cases. But firstly, a little bit of background. The casual employment landscape has seen significant change in the last few years. Before COVID, there were approximately 2.6 million casual employees in Australia. But due to recent industrial relations developments, it's likely that this number will significantly reduce. COVID and the eligibility of JobKeeper payments has caused employees to consider the benefits of being permanently employed. However, from an employer's perspective, it is the legal precedent from the cases of WorkPac and Skeen and WorkPac and Rosato that are incentivising some employers to reconsider the basis on which they employ staff going forward. So the most common reason that employers classify an employee as casual is that the business cannot afford to lose an employee for 4 weeks of leave. And the 25% casual loading has been used by employers to overcome this problem. And financially, from an employee's perspective, the 25% loading often outweighs the 4 weeks of annual leave, sick leave and long service leave that the employer would otherwise have to account for. Casual employment was designed to limit an employer's liability for entitlements. It enables an employer to terminate an employee's employment with relative ease and little recourse. In terminating an employee, a casual classification avoided redundancy payments, and more specifically, it was introduced for fluctuating industries like tourism, retail and hospitality, where employers wanted to have an employee permanently available but didn't want to create a long-term commitment. What pre-2018, or casual loading, it's prescribed under the Fair Work Act. And pre-2018, there was a perception that irrespective of the hours worked by the employee, provided the employee received casual loading, the employee was a casual employee. That's irrespective of the hours worked by the employee. However, unfortunately, since 2018, things have changed when the court did not adopt that same view. And I come to the case of WorkPac and Skeen, which was the first decision of the court to really look to categorise casual employees and set out an indicia for determining whether or not an employee is permanent or casual. In this case, there was a Mr. Skeen, and he was employed by a labour hire company, WorkPac Proprietary Limited. Skeen was a fly-in, fly-out dump truck operator at the Clermont mine in Queensland. In 2010, he signed an employment contract, and the heading was it was a casual employee terms and conditions of employment contract. The contract provided that he be employed on a casual basis, paid an hourly rate of $50, and his employment could be terminated on only 1 hour's notice, which all of this, they're good indicators of an employee being a casual. However, the problem here was that during Mr. Skeen's employment, he regularly worked 7 days on and 7 days off with 12.5-hour shifts every day, and he did so for more than 2 years. Further, his roster was determined 12 months in advance, so he knew exactly what he was going to be doing for the next 12 months. So when he was terminated by his employer, Skeen claimed annual leave entitlements on the basis that he was not, in fact, a casual employee. And unfortunately for WorkPac, the court agreed with him, and they awarded him compensation for the unpaid annual leave entitlements that he hadn't taken, okay? And this was despite the fact that he had received from his employer the 25% casual leave loading. So, as I said before, WorkPac and Skeen set out the indicia, the indicators of what makes an employee a casual employee. And this is what you've got to be aware of, as an employer when looking at the arrangements of your employees. So the first one there must be, to be a casual employee, there must be no continuing and indefinite work. So employment contracts that purport to guarantee a casual employee regular ongoing work may indicate the employee is in fact a permanent employee. There must also be irregular work patterns. So in retail and hospitality industries, you shouldn't have an employee opening and closing the shop and doing the same regular shifts. In Skeen's case, and in a lot of fly-in, fly-out employment matters, we see employees doing night shifts for the next month, for example. And this, in my opinion, would be a good indicator that someone is a permanent employee and not a casual employee. There must also be uncertainty of work. In Skeen's case, as I said before, he was rostered on for the next 12 months. He knew exactly what he was going to be doing and where he was going to be working for the next 12 months. That, is not, that's an indicator that he's a permanent employee and not a casual. There must also be discontinuity of work and intermittency of work. So what you're looking for here is irregular shifts, a different number of hours of work each week, even some weeks where the employee has no work are obvious good indicators of casual employment. Unpredictability of work, that's despite an employee wanting certainty, a casual employee should only receive 1 or 2 days notice for an upcoming shift. And there must be no firm commitment between the employer and employee in terms of, ongoing work. Unfortunately, however, casual employees, they don't want the above. They want certainty, okay? But what you might also find if you go and talk to an employee about this, and we've had some inquiries just recently where employers have been employing their employees on a casual basis, and employers have raised this with these issues with their employees, and the employees have said, well, you know what, we actually want to, we want to keep the current regular arrangements that we've got, but we want to continue on as casual employees receiving the casual loading. So if you're in that situation as an employer, really you're going to need to get some advice, okay? You can't, as a lawyer, I can't give, or lawyers can't give general advice. They've got to really look at the specifics with you, okay, and run through the arrangements that you have with your employees to find out, to ascertain what your options are. Okay, more recently, there's been another case involving Workpac as well, and a Mr. Rosado, and the decision in this case has certainly been a cause of angst for employers. So in this case, you had a Mr. Rosado. He was a drive-in, drive-out employee at the mines. He worked a 7-day on, 7-day off roster. He worked the same shift patterns, 12 hours a day for 3.5 years. And again, as in Skeen, he knew exactly what he was going to be doing for the next 7 months. He had a roster that was given to him by his employer. And, being a fly-in, fly-out worker, he'd go out to camp. There was no real opportunity for him once out there to decline, the work for the week. And in fact, there was no real opportunity for him to say, no, boss, I can't come in today. I feel like having a day off. So the main issue created by Workpac and Rosado is that despite Rosado being employed as a casual under his employment agreement, and despite receiving a casual loading, the court looked at the nature of the employment as a whole and determined that Rosado was in fact a permanent employee and therefore entitled to annual leave, sick leave and long service leave. Okay, and again, so what you had there was Rosado during his whole time of employment had been getting the casual leave loading, and then you had a court basically awarding him compensation for the leave that he didn't receive. So what should you be doing if you're an employer of casual employees? Okay, firstly, we recommend that you have a look at your employment arrangements. Okay, you should have separate agreements for casuals and full-time employees. And with the casuals, in your agreement, you should specifically identify the base pay rate and the casual loadings in the agreements. Secondly, in terms of rostering and dealing with your casual employees, you should ensure that you provide no guarantee of ongoing work beyond, probably 1 to 2 weeks. That's a practical decision there, really. So whilst you may have monthly rosters for your permanent staff, you may want to implement shorter rosters for casuals. You should only give casual employees inconsistent and irregular shifts, okay? And you can also internally audit these systems on a regular basis by simply comparing consecutive pay slips and rosters for your casual employees. If you notice patterns or similarities between these documents from week to week, then you may need to reassess that employee's engagement, okay? So back to this issue of double dipping that I raised before following the case of Rosado, okay, Workpac and Rosado. From an employer's perspective, the main question we've been receiving is concerning double dipping. In particular, employers want to know why they have to pay permanent leave entitlements after they've already paid casual loading. Employers often suggest that employees are double dipping and getting paid twice. Unfortunately, this case of Rosado, the court held that it's not double dipping, and the main reason it is not considered double dipping by the court and why casual loading cannot be used to offset what an employee may be liable to pay by way of permanent entitlements are as follows. One is that the Fair Work Act provides that there is no cash equivalent to employee entitlements. What this means is that monies paid on account of casual loading cannot be equated to entitlements. In the eyes of the court, 4 weeks leave entitlement does not have a numerical value, so cannot be offset against. Casual loading was deemed financial compensation for an absence of entitlement, not a payment instead of taking the entitlement. So a casual employee, if an employee is a genuine casual employee, they're not entitled to annual leave, okay? So the 25% loading is, it's a compensation for the absence of that entitlement. Whereas if you are incorrectly classifying your employee as a casual, and in fact, they're getting regular shifts, they have an expectation of ongoing work, therefore meaning that they're most likely permanent employees. What the court is saying is that you cannot, the 25% loading that you're paying them, you cannot pay them that instead of giving them their entitlements, okay? There's a subtle distinction there. Casual employees, they have no right to these entitlements, annual leave, so they're compensated for it. If your employee is in fact a permanent employee, you can't pay them a casual loading instead of, okay? It's not compensation for you not giving them their entitlement. Okay, so what protections are there for employers? Well, in terms of protection, whilst the decision of WorkPac and Rosado is currently being appealed to the High Court, under the Fair Work Act, an employee can claim up to 6 years post-dating their employment. So, you may have employed an employee. So there's very little protection for you, okay? If you're getting it wrong, okay, and an employee gets wind of this, okay, then, they can look back 6 years, okay, under the statute of limitations and go you for that. Okay, and there are instances that I'm aware of where employers have all their staff employed as casuals, and yet they work regular shifts. These employers are, at the moment, with the law as it is, they're very exposed. Okay, so they need to go and get some advice on this. So what can you do as an employer? Okay, well, you've got to give, the first thing you've got to do, okay, is give consideration of the arrangements that you have in place with your employees. So for those employees within your business who are considered casual, you may want to consider having a greater variety of hours and times in their rosters. You may also look at having a larger pool of casual employees, not just one or two. By having more casual employees, it'll allow for greater variance in their employment, okay? And you won't come unstuck either, okay, by having no one, for a particular roster. Ensure that they work irregular hours, with no guarantee of any days or set hours. And, you've got to be looking to ensure that they have no reasonable predictability that their work will continue. and you're rostering, really just look to roster them no more than 1 or 2 weeks in advance. So all of that, is probably not particularly attractive to a lot of employees unless you're, in the hospitality industry or something like that. It really is that's the first step. You've got to regularly undertake internal audits, and simply looking at your pay slips of your employees over a period of time will give you a good indication as to you're looking for, is there regularity in the manner in which you're employing these people. If there is, okay, you're going to have to mix it up if you want to keep them as casual employees, okay? But even then, I guess, if you've got somebody who's been working regular hours and then you start to say, hey, I'm going to suddenly reduce your hours and mix it up, I think that could cause you some real trouble. So, they might say that, hey, you're effectively dismissing me, constructively dismissing me, and that could cause you problems. So then your only other option is to really go to them and say, well, instead of having you as a casual, we want to offer you permanent employment, all right? And you're going to get, well, we've had some people clients come to us and say, we're looking to do this with the employees who we've employed casually, but we're getting some pushback because they want the 25% leave loading, okay? We've given some consideration to what you can do there, and one option is to offer them permanent employment, but with the option to cash out their leave every 12 months, okay? So to do this, all right, the court has said that, yes, as a financial incentive, you can offer to pay out an employee's leave as a lump sum cash payment. But in order to do this, you've got to check a few things, okay, because in all circumstances you can't. Firstly, you've got to make sure that the relevant industry award that is applicable to that employee allows you to do that, okay? Most do, but some won't, okay? Also, you've got to bear in mind that you'll only be able to pay the employee or cash out the 4 weeks annual leave after the employee has accrued the leave, okay? So you can't go, right, 4 weeks leave a year equates to X amount of dollars, I'm going to pay it out gradually over the 12 months. You've actually got to employ the employee, have them work their 12 months, accrue the 4 weeks leave, then pay it out, okay? And also, the other thing that you've got to do is you've got to make sure that you've got an employment agreement with them, and that in that employment agreement, there is actually a provision or a clause in that employment agreement that allows or provides for the cashing out of entitlements in the employee's contract.
Cheers.
So thanks very much for that. If you've got any questions, yes, fire them. Please feel free to fire them through.
Thanks, Ben. Yes, please get your questions through to us. We'd love to hear from you guys. And hopefully we can answer those best we can. So, Ben, just in a quick nutshell, I don't know if we can go back on those, go backwards. Sorry, Wendy. Go backwards. I just wanted to go back to that. There was a bit of a checklist, I suppose you would say.
Yeah, the indicia for
that one.
Yeah.
Do you think our listeners out there could maybe use that as a little bit of a checklist, and if they do have anyone who doesn't meet that, there's they don't have irregular work patterns, that they must probably get some advice then?
Yeah, look, that's your starting point, okay? It's pretty clear on what they're talking about there, certainty of work, irregularity, all that sort of stuff. That's your starting point, okay? The first thing you've got to do, it's the nature of the employment that is the most important consideration here, okay? If as an employer, you are incorrectly classifying an employee as a casual when they're in fact a permanent, you need to do something about it, okay? And I think that you're running a real risk if you look to do something about your situation without getting, professional advice on this.
Yeah. Because I suppose, hey, look, let's look at it in the real world, Ben. Hey, look, I'd imagine some of these employees probably did start off casual, and they were, 15, 20 hours a week. They become very valuable to the organisation. They work themselves up to 30, and they do a full week. They might do a full 38-hour week. They're still on that casual rate.
Yes.
I'd imagine the employee's probably pretty happy with that rate.
Yes.
What's Skeen's case there, he was getting $50 an hour.
Yeah.
To have that discussion with him and reduce it down to say $40 an hour, to sit down as an employer and an employee, there's going to be some tough discussions there, isn't there?
Yeah, they're not going to be happy about that necessarily. So, as I say, before you have that discussion with them, go and see somebody, okay? Get some advice as to what your options are, and how best to work through this situation. Yeah, as I said, that particular scenario that you've given me there, the employer is going to have to cover themselves, okay, protect themselves, and really they're going to have to look to put this employee on as a permanent, okay? Otherwise, they run the risk that that employee gets a bit disgruntled with them, and says, "Buggy, I'm off. Oh, and by the way, I'm gonna claim my 4 weeks annual leave. Actually, I might get my long service leave while I'm in there as well as all my sick days. I'm going to claim all of that against you, okay, for the last 6 years." Okay, so the employer's exposed. I've had people come to me and say, "Oh, what can I do? Can I get the employee to sign a letter that I've offered them full-time employment, permanent employment, and they've rejected that?" Okay, well, yeah, you can do that, and it's evidence that you're trying to do the right thing. But I think at the moment there's no guarantee that a court is going to approve of what you've done. Okay, I think that if it all comes down to the nature of the employment arrangement. If the employee is employed on a regular basis, they've got an expectation of ongoing work, you really are going to have to look at converting them over to permanent employment. Okay, and you will have employees that are not happy with that, but there are options. Put them on a permanent contract, and look to see whether you can enter into an arrangement where you cash out their employee entitlements. And financially, they're probably going to be. It's going to be a different arrangement in that they're maybe not going to get the same amount each week, but at the end of the 12 months, you can probably, ensure that they end up pretty much in just the same financial situation as they would otherwise have been. And you're protecting yourself as well.
As well, yeah, for sure.
As the employer. What's that question up there, George?
Yeah, Joy's got one there about seasonal workers. Will this affect our classification of casuals as work is never certain?
I think, Joy, that you're probably you have a seasonal facility. Okay, I'm not sure what type of facility it is, but this is seasonal facilities. This is why we have casual employment. Okay. in your situation, you just got to look at so they're obviously they're not on long-term employment contracts. That's good. With your rostering, just mix it up a bit. Okay. And, as I said before, probably don't have a roster that gives them, 1 or 2 months out. Just make it a 2-week roster, and then, give them the next roster after that. Okay. That you'll probably be okay with that.
Yeah. Yeah. And Ben, I can even, I know this is quite extreme. I can sort of see situations where, you employ a bookkeeper to come in every Thursday, come and do some data entry, come in and do the wages. They come in for, 5 hours every Thursday. Obviously I'm pretty sure they would probably be a casual arrangement. There's probably not really irregular work patterns. The work's probably fairly certain. Discontinuity of work, there's that possibility, I suppose.
It is funny when you read those indicia. I mean, that's a good example, okay? And, shows you what a minefield this is. They come in for 4 or 5 hours every Thursday. I still, looking at that, they've probably got a regular work pattern.
Yeah.
I think
unpredictability of work. I don't think there's unpredictability there.
Well, I think in that situation,
the only reason I say that, I think people have always thought that it's more about the person who's on a casual rate and is working 38-hour week, isn't it?
Yeah, or even a 25-hour week, because that would be permanent part-time.
Part-time.
I still think that if they're working 4 or 5 hours a week, you'd put them as casual. I wouldn't be worried about that. You're not going to put them on a contract that says, you'll do this, you'll work like this for 2 years. Okay. You'd have some, arrangement with them, that, I want you to come in there. You're not going to have a formal fixed term contract with them. So that lessens the commitment that you have with them.
Yeah.
Although you're right, Mark, it certainly, there's intermittency, I guess, in that it's not, it's week to week. So I think they tick that.
Yeah.
It's 7 days since they had their last shift.
Yeah.
Uncertainty of work. Well, I guess you'd be arguing that, if you didn't have them on a fixed term contract, you could end it at any time.
Yeah.
I still think that you'd be fairly safe in that situation to keep them as casuals.
Yeah.
I think really what we're looking at is, if they're working 20 odd hours a week, 20, maybe even, 15 hours a week and beyond, and this is all subjective, that you need to be looking at, okay, are they in fact permanent
workers?
Yeah, permanent part-time workers.
Yeah. And I suppose just to protect yourself, if you can create some irregular work patterns, if you can put a few more of those in there, I suppose that helps you out, whether you're under the 25, over the 25, or even to the 30. I think But hey, look, it's always going to be tough, as you said. There's for some people there might be some issues because you can go back 6 years on this.
Yes,
statute of limitations. Probably more about protecting yourself going forward now, isn't it? Now that we know this as well.
Yeah, look, for as long as this case, I mean, I don't think you can do much about, what is done. Okay, if you get the difficult employee or an employee that cottons onto this, and takes a dislike to you and wants to make your life difficult, it just comes back to the nature of the employment. So if you've employed somebody, they've been working for you for 4 years, 20 hours a week, okay, 48 weeks or 52 weeks a year or whatever, okay, they haven't been taking their paid holidays or anything like that, they're going to be able to potentially make a claim against you.
Yeah. Look, it's very open at the moment, isn't it? Very subjective, isn't it?
Yeah. But I just, it's industrial relations law. You look at these awards, they're 150 pages thick. You get looking at the Fair Work Act, that's 1,000 pages thick. You want to read Workpack and Scheme, it's all as clear as mud. And that's a lawyer saying that, okay? It's difficult to work out. So, as an employer, you've almost got to have a quasi-law degree. I can't stress enough, if you find yourself in this situation and you've got some concerns, go and see a lawyer, who has some expertise in this area, okay? Get some early advice, and look to what's done is done, but moving forward, a good lawyer with experience in this field will be able to help you navigate matters going forward and help you to engage with your staff to resolve this issue.
Yeah. And on that note, I suppose, Ben, hey, look, we don't have too many more questions. Well, there's no more questions. And as Ben said, hey, look, do get some advice. Go and see the guys at South Geldard. Have a chat to Ben and his team. I'm sure they can help you out and just maybe be able for you guys to sleep well at night, knowing that you've got all those things at bay, especially when it comes to casual employment. It seems to have raised its head. We need to make sure we put all that risk at bay anyway.
Yeah, I didn't make a point there, but in addition to, being potentially liable for all your unpaid entitlements, there's penalties there that can be imposed as well. So it's important to deal with it, get it right moving forward. I think if you find yourself in trouble, okay, and a court sees that you've actually had a good go at sorting it all out moving forward, that's also going to
Work in your favour.
Yeah, work in your favour and put you in a favourable light at least. And you can say to the court, hey, this is a genuine error. Yeah. Okay, it's not something that I was aware of and I've just chosen to ignore.
Yeah. No, wonderful.
Thank you, everyone.
Hey, thanks again, Ben.
I hope it was helpful.
Appreciate your time. Once again, thank you all for listening in. Listening to our next one, I believe it's probably more around some of the expansion or more detail on the budget, plus a bit of JobKeeper as well. So listen in and we will be in touch. We'll shoot an email out. This recording will also go out to you guys as well. But and we'll let you know what the next one is while we're at it. Thanks for your time, eh? Bye now.
Thank you.